When police respond to a mental health crisis, the stakes are high, lives often hang in the balance, and so does the law. This week, we're diving into Scott versus Smith, a 2024 Ninth Circuit case that's about excessive force and mental health calls. I'm Steve Serbalik, and I'm a panel attorney with ASCOPS in Arizona. I'm going to give you the background that the Court of Appeals considered, but before I do, know this. These facts may not be accurate. The case was decided on summary judgment, meaning that the Court of Appeals considered facts in a light most favorable to the plaintiff, to the party claiming the officers did something wrong. A jury reviewing the case at trial could find differently than what I'm about to recite as to the alleged facts in this case. With that caveat, here's what the Ninth Circuit considered. In March 2019, Roy Scott, a Las Vegas man in mental distress, called 911, reporting assailants outside his apartment with a saw. Las Vegas Metro police officers Kyle Smith and Theodore Huntsman responded, knowing Scott was mentally ill. Scott wasn't suspected of a crime, held a metal pipe at his side, and complied with orders, even handing over a knife handle first. But things went south. The officers grabbed Scott, took him to the ground, and pinned him face down. Huntsman pressed his body weight on Scott's neck and back for 1 to 2 minutes, while Smith held his legs. Scott struggled, cried out, and became incoherent. After handcuffing him, Scott was unresponsive, his face bloody from thrashing on the ground. He was pronounced dead from restraint asphyxia. Scott's daughter, Rochelle, and his estate sued, claiming excessive force under the Fourth Amendment and violation of familial association under the 14th Amendment. Here's what the Ninth Circuit decided on July 30th, 2024. The court denied qualified immunity for the officers on the Fourth Amendment claim. Why? They leaned on a 2003 case, Drummond versus City of Anaheim, which clearly established that using bodyweight force on a prone, unarmed person's back and neck, especially someone mentally ill and not suspected of a crime, was unconstitutional. In the facts viewed most favorably to the plaintiffs in this case, Scott complied, posed no threat, and was restrained when the officers applied pressure, causing his death. The court said a reasonable jury could find this force excessive, violating Scott's rights. But on the 14th Amendment claim, Rochelle's loss of familial association, the court reversed. While the officers' actions violated her rights, the law wasn't clearly established in 2019, so they got qualified immunity on that claim. Now, let me be clear, I don't always agree with the courts, and I have my doubts that a jury will find these facts are accurate when viewed in a fair presentation at trial. Mental health calls are chaotic, and officers often have little time to make split-second decisions. The Ninth Circuit's ruling puts a heavy burden on police to navigate these situations perfectly, especially when someone's holding a pipe and acting unpredictably. But as your ASCOPS attorney, I've got to level with you. The court expects you to know the standard outlined in cases like Drummond. If you're restraining someone prone, especially if they're mentally ill and not an immediate threat, body weight on their neck or back can be seen as deadly force. And if it leads to injury or death, you could lose qualified immunity. Here's my advice for Arizona officers and others in the Ninth Circuit. Know the law. Drummond, in this case, Scott versus Smith, are now your guideposts. Avoid prolonged pressure on a prone person's upper body, especially if they're not resisting or a clear danger. De-escalate when possible. Mental health calls require patience. Use verbal commands and distance if the situation allows. Document everything. If force is used, your report needs to detail why it was necessary. Courts will scrutinize it. And of course, reach out for support. If you're unsure about policy, or especially if you're facing a critical incident, contact ASCOPS. We're here to back you up. And finally, on that, reach out immediately. Make sure that everyone you work with has legal coverage. On far too many occasions, I've been at critical incident scenes and learned that one or more involved officers doesn't have legal coverage. That, in my opinion, is insane. Talk to your coworkers and make sure they're covered. ASCOP's monthly dues are nothing compared to the stress of facing potential criminal charges entirely on your own. Rant aside, back to the big takeaway for Scott versus Smith. Courts are cracking down on use of force and mental health crisis. And Scott versus Smith is a wake-up call. I get it. Officers are human, not perfect, but the Ninth Circuit expects you to act with precision, especially when lives are at stake. And if you're involved in a critical incident, they expect accurate and detailed articulation of your use of force, something that me and other ASCOPS attorneys can assist with if you are a member. If you have any questions or comments on this topic, please leave them down below. Don't forget to like, follow, and turn on notifications. It helps the channel reach more officers like you. Be on the lookout for new videos. They come out every Sunday at 5:30 p.m. Arizona time. I'm Steve Serbalik. Thanks for watching and stay safe out there.